Hello, and welcome back to our channel. In the video, I will be discussing the various visa and green card options available for individuals with exceptional abilities or expertise in their respective fields. So let's get started. I would like to begin our discussion by focusing on the EB-1A green card option. This particular green card category is designed for individuals with extraordinary ability in their field. This category applies to those who have reached the top of their field, whether it be in sciences, mathematics, sports, business, or other such fields. If you possess such exceptional abilities, you may be eligible to apply for a green card through the EB-1A category. One of the major benefits of this option is that it allows self-sponsorship. Unlike many other options, this category does not require that an employer petition for your green card. You may petition for your green card on your own, without needing an employer or family member to sponsor you. Obtaining a green card by way of self-petition is a highly attractive option for obtaining lawful permanent residence in the United States. You may be wondering how the USCIS determines whether someone has an extraordinary ability. To qualify under the EB-1A green card category, USCIS evaluates applicants based on certain criteria. One way to qualify is if an applicant has a major one-time achievement. If an applicant doesn't have a major one-time achievement, such as a Nobel Peace Prize, then they must satisfy at least 3 criteria from a list of various criterion. One of the criteria that can help demonstrate extraordinary ability is to provide evidence of winning nationally or internationally recognized prizes or awards in your field. Another criteria that can help establish extraordinary ability is to demonstrate your membership in an association or organization that requires exceptional achievement in your field as a prerequisite for membership. You could also establish extraordinary ability by judging the work of others in your field. For example, partaking in a panel of judges for a highly regarded competition in your field could be used towards showing your exceptional ability. Another criteria that can contribute to establishing extraordinary ability is to provide evidence of publications that feature you or your work, such as press releases or articles. Also, having authored scholarly articles, books, or other publications in your area of expertise can further demonstrate your exceptional ability in the field. Additionally, you can demonstrate extraordinary ability by providing evidence of high compensation in comparison to others in your field. There are other criteria as well. USCIS typically follows a 2-part evaluation process to determine if an applicant meets the requirements for EB-1A. The first step of the evaluation process involves a review of all the evidence submitted by the applicant to determine whether they meet the evidentiary threshold. Specifically, USCIS assesses whether the applicant satisfies at least 3 of the above-mentioned criteria used to demonstrate extraordinary ability. Once this threshold is met, the application moves on to the second step of the evaluation process. The second step in the evaluation process is called the final merits determination, during which USCIS evaluates the application as a whole. This involves a review of all the evidence presented by the applicant to assess whether they have truly risen to the top of their field. The final merits determination considers the totality of the evidence provided by the applicant and provides an overall assessment of the applicant's qualifications for EB-1A. This concludes our overview of the EB-1A green card process. The next option we'll discuss is the EB-2 National Interest Waiver, also referred to as EB-2 NIW. This is an excellent option for individuals whose work in the United States would be of national interest to the country. This option is especially suited for individuals in fields such as medical research or scientific innovation, where their work has the potential to benefit the country as a whole. For instance, a cancer researcher or a scientist working on developing a cure for a specific disease may be eligible for the EB-2 National Interest Waiver. Similarly, any endeavor that would improve the nation's health and safety could be eligible for an EB-2 NIW. EB-2 NIW cases grant permanent residence to individuals based on their abilities and contributions to the United States. The significant advantage of the National Interest Waiver is that, like the EB-1A, the EB-2 National Interest Waiver does not require an employer to sponsor the applicant. This means that an individual can apply for a green card through self-petition without the need for a job offer or company sponsorship, which is an enormous benefit. Now, let's dive into the requirements for the EB-2 National Interest Waiver. To qualify for this waiver, you must first satisfy the requirements for the EB2 immigrant classification. Also, you must demonstrate that the work you plan to do in the United States has substantial merit and national importance. Further, you must also show that you are well positioned to advance your proposed work in the United States. Lastly, you must establish that the endeavor is in the national interest of the United States, and therefore USCIS should waive the standard requirements of having a job offer from a U.S. employer as well as waive the labor certification requirements. Keep in mind that it is important to note that you must demonstrate that it's in the national interest to waive these requirements. The O1 visa is a third option for individuals with extraordinary abilities in a particular field, similar to the EB1A discussed earlier. However, unlike the EB1A, the O1 is a non-immigrant visa that does not directly lead to a green card and is temporary in nature. To qualify for the O1 visa, individuals must demonstrate extraordinary ability in a field such as math, science, athletics, arts, or business. This can be done by satisfying at least 3 criteria from a list of criterion, including receiving prizes or awards, judging the works of others, being a member of an association that requires outstanding achievement, or receiving high compensation compared to others in the field, and other such criteria. Let's discuss the key differences between the O1 and the EB1A visa categories. While both visas require demonstrating exceptional ability, there are some notable distinctions. First, the O1 visa requires the applicant to have a U.S. agent or employer to file the petition on their behalf. In contrast, the EB1A visa is eligible for self-petition, meaning that an individual can apply for the visa on their own without the need for any sponsor. Second, the O1 visa is a non-immigrant option, which means it does not provide a direct path to a green card. On the other hand, the EB1A visa is an immigrant visa category that enables someone to obtain permanent residence in the United States. Lastly, there is a much higher level of scrutiny applied when reviewing an EB1A application compared to an O1 application. Although both visas require demonstrating exceptional ability, the standard for approval is lower for the O1 visa. Overall, the O1 visa can be an excellent option for individuals who wish to come to the United States temporarily to work in their field of expertise. However, if an individual wants to obtain permanent residence in the United States, the EB1A visa may be a better fit. In summary, this video provided a broad overview of 3 options for individuals to obtain a visa or green card based on their exceptional abilities or work in the national interest. Please note that the information presented is highly technical and does not constitute legal advice. To receive proper guidance, it is essential to consult with a qualified U.S. immigration lawyer who can assess your individual qualifications and circumstances and provide tailored advice. Thank you for watching our video. Don't forget to like this video and subscribe to our channel to stay up to date with all of our videos. See you next time.